So good morning. The topic for today is Indian Contract Act as per the Indian Contract Act 1872. The Indian Contract Act 1872 defines a contract as an agreement enforceable at law. So for a contract to be valid, it has to have two conditions. One is an agreement, and that agreement has to be enforceable at law. What do you mean an agreement enforceable at law? There are actually two kinds of agreements. One is a legal agreement, another one is a social agreement. For example, I invite my friend home for a cup of tea. She sincerely comes home to have tea, and I forget the whole invite and I go home, I lock my house and go somewhere. Can my friend take me to the court of law? No, because it is just a social agreement. She cannot go to the court and sue telling that she had invited me for a cup of tea. I went home but she locked the house and she walked out, so I'm insulted. She cannot file a case in the court because it's a social agreement. But when an agreement with an intention of suing another person in the court of law or trying another person in the court of law is entered into, that agreement becomes a contract. That means if the contract is not carried out as per the terms and conditions, the parties to the contract can sue each other in the court of law, and the law will enforce the contract. The law will ask the parties to carry out the contract, or the law will enforce the contract. So contract is an agreement enforceable at law. Again, the Indian Contract Act defines an agreement as every promise and every set of promises forming consideration for each other. See, when I say every promise, here I ask somebody, will you buy my car? The other person says, yes, I will buy a car. So when the other person has given a word saying, yes, he will buy the car, that's a promise. Or every set of promise. See, when I tell somebody, I'm willing to sell my car, I'm giving him a promise. And when the other person says, yes, I'm willing to buy a car, there's another reciprocal promise given. So it's every set of promise forming consideration. What do you mean by the word consideration? Consideration means something in return. For example, when I sell my car, the other party gets the car and I get money. So both the parties here have got something in return. That's called as consideration. So an agreement is every promise or every set of promise, and for the promise to be valid, it has to have consideration. And if there is a consideration, then every promise or every set of promise forming consideration for each other becomes an agreement. And there are certain terms which you should get used to when you're studying the Indian Contract Act. One such important term is consciences addendum. Consciences addendum is when both the parties to the contract have come to an agreement on the same thing at the same time. See, for example, I have 5 cars with me or 3 cars with me, an Alto, Swift and a Wagoner. And I am willing to sell my Swift, and I ask the other party, are you willing to buy my car? The other person is impressed with my Wagoner. He says yes. So he is thinking that I am selling my Wagoner, but I have in mind that I am selling my Swift. Here the consent is given, but both the parties have no consciences addendum. That is, both the parties have not agreed upon the same thing at the same time. Then there is no consciences addendum, and when there is no consciences addendum, there is no contract. That is, both the parties, when they give a consent, they should have agreed upon the same thing at the same time. Now I am going to tell you the legal rules relating to of a valid contract. The first rule, you tell me now. I told you there should be a person who's placing an offer and there should be a person who's accepting the offer. So obviously there should be an offer and an acceptance. The person who's placing the offer is called as the offerer or a proposer or a promiser. The person to whom the offer is made is called the offeree, a promisee or a proposee. And the person to whom the offer is made, if he accepts the offer, then he becomes the acceptor. For example, A asks B, will you buy my car? Here A is the offerer, promiser or proposer, and B is the offeree, promisee or proposee. If B says, yes, I will buy the car, then B becomes the acceptor over here. So for a contract to be valid, there should be 2 parties, one party making the offer and the other party accepting the offer. Rule number 2 of a valid contract is both the parties should have the intention to enter into a legal relationship. I told you already, a social invitation does not lead to a contract. For example, I told you, I invite a friend over to my house for a cup of coffee. There is no valid contract. He cannot sue me in the court of law. So for a contract to become valid, there should be a legal obligation or a legal tie. There was a very famous case law over here, Balfour versus Balfour. Balfour and Balfour, as the name suggests, they were husband and wife. Mr. Balfour had to leave to London, leaving his wife in Sri Lanka. So when he leaves to London, he tells his wife that he will pay $30 every month for maintenance. And after he left, he started sending the money, but after a certain period, he stopped sending $30. Now his wife sues him in the court of law, asking for the maintenance $30, which Mr. Balfour has promised. And the court says Mr. Balfour need not pay her $30 because when he agreed or promised to pay her $30, it was just a social agreement, and there was no legal intention, or there was no intention to create a legal relationship. So the court, the judgment given by the court was Mr. Balfour need not pay Mrs. Balfour because there was no intention to create a legal relationship. So if you have to enter into a contract, both the parties should have an intention to create a legal relationship. And the third rule which makes a contract a valid contract is consideration. I already told you, consideration is something in return. This something in return can be an act or it can be an abstinence. For example, I promise to sell a car to a person, the other person promises to buy a car, an act. Or I promise to pay a person certain amount, in return promise, he promises not to sue me in the court. That is an abstinence, that is promising not to do something. So it can be an act or it can be an abstinence. Consideration can be in the past, present or future. For example, I ask in the railway station, I ask a person to carry my luggage, and after he carries my luggage, I pay him. For me, the consideration is in the present. For him, the consideration for an act that is done in the past. So consideration can be in the past, consideration can be in the present, or consideration can be in the future, where I promise to do something. But for a contract to be valid, there should be consideration. And again, the law tells you the consideration need not be adequate, but there should be a consideration. Only then it becomes a valid contract. And the fourth essential element of a valid contract is capacity of the parties. Now, who can enter into a contract? A person who is above 18 in the court of law, that is a major, a person of sound mind, and a person who is not restricted by any court of law. Only these persons can enter into a contract. I repeat, a major, a person who is above age of 18, and suppose a guardian is fixed, then his age should be above 21. A person who's of sound mind, a lunatic cannot enter into a contract. Maybe a lunatic can enter into a contract when in a time period where he's got sound mind. If suppose a person has a problem where different intervals he goes into unsound mind, and different intervals he has a sound mind, then when he's got a sound mind, he can enter into a contract. A drunkard also, when he is drunk, he cannot enter into a contract. And if a person is restricted by the court of law, then he cannot enter into a contract. Other than that, anybody can enter into a contract as per the Indian Contract Act 1872. And the next essential element is free and genuine consent. This is very important. A person entering, both the parties, I told you already, consensus ad idem. Both the parties entering into the contract should have given a free and genuine consent to the contract. That is, they should have agreed upon the contract in a very free and genuine manner. For example, each essential element is going to be a big chapter which you're going to study in detail in future. But I'm just giving you a gist of it now. So, for example, if a person has been threatened to give his consent, that's called coercion. Suppose I threaten you, I have threatened to create some harm to you or to a property or to somebody close to you. For example, I abduct a person, or I take away some important files from you and I tell you, if you don't do this, I will not give you the file. So this is coercion. If I threaten and force you to enter into a contract, or if I tell you a lie purposefully, I know it is not the truth, but I make a representation knowing which is not the truth, and I make you enter into a contract, it's called fraud. Or when I make a representation, I do not know that it is not true. Innocently I make a representation, but it's a wrong representation based on which you have entered into a contract. It's called misrepresentation. Or there is a mistake on both the parties and we enter into a contract, which is called mistake. Or I'm in a position where I'm able to influence your decisions, called undue influence. For example, a teacher-student, a doctor and a patient, where a doctor is in a position to exercise his influence on the person to make a decision according for his benefit or something. If a contract is entered into using the undue influence, then the consent is not free. So consent has to be free from coercion, undue influence, mistake, misrepresentation and fraud. Both the parties should have given the consent 100% freely and genuinely. Only then there is a contract. Now when suppose I am in a position to, suppose I am going to file a case in the court of law telling them the consent is not free, here one thing is taken as a great witness, the suppose if the consideration is not adequate. See, the court tells you the consideration need not be adequate, there should be consideration, that's it. But then if the consent is not free, I can take that consideration is not adequate as a witness to prove that the consent is not free, and this stands as an evidence. Consideration not being adequate stands as an evidence where it can be used to prove, see, my consent is not free, otherwise if the consent had been free, I would not have accepted for such a small consideration. And the next rule, lawful object. Both the parties who are entering into a contract should enter into to do a business or whatever it is which is only very legal. For example, I cannot hire a person to hit somebody, or I cannot hire a person to smuggle something. Here the object is not very lawful. So only if the object is legal, because anything that is not lawful cannot be taken to the court for suing. So the court does not accept anything which is not lawful. So only if the object is lawful, it is enforceable by law. Only if something is enforceable at law, it becomes a contract. So if it is not lawful, then the court doesn't take it, and therefore doesn't become a contract. And agreement not declared void. There are certain agreements which is void ab initio, that is void at the beginning itself. For example, you cannot enter into a contract with a person restraining marriage. You cannot tell a person you cannot about a person who's above 18. You cannot tell a person that you cannot enter into a marriage with this person or that person. You cannot enter into an agreement restraining marriage at all, because that's against the law. Or you cannot enter into a contract restraining somebody's business, a wagering agreement. All these kinds of agreements are void from the beginning. So these agreements obviously does not get converted into a contract. And contract for sure should be certain, and there should be a possibility of performance. You cannot enter into a contract with a person telling, I will bring back your dead father or a mother who's already not alive. So you cannot tell them, I'll do some these kind of magic or gimmicks, which is a contract. If it is not, if there is no possibility of performance, then there is no contract at all. And the last one is legal formalities. If there is a rule that a contract has to be written, it has to be in certain stamp papers, it has to go through certain legal formalities, a contract has to follow all those legal formalities, only then a contract becomes a valid contract. So for a contract to be valid, there should be an offer and acceptance, there should be an intention to create legal relationship, there should be lawful consideration, there should be free and genuine consent, the person should have capacity to contract, there should be an agreement which is not declared void, there should be lawful objective, there should be legal formalities, and the last one, there should be certainty and possibility of performance. Thank you.